Hello, welcome to Sleep Galaxy Tales. My name is Reggie. Tonight I will be reading from the Federal Register. These entries are formal, procedural, and not important to remember. You do not need to follow along. You do not need to understand any of this. If you find these readings helpful, you may choose to like this video or follow the channel so you can find similar readings again. For now, you can simply rest and let the register continue. I will begin. The Federal Register, Volume 60, Number 1, Tuesday, January 3rd, 1995. Proposed Rules. Page 86, published by their Government Publishing Office. Document number 94-32313. Agency. The Advisory Council on Historic Preservation. Title: Protection of Historic Properties. Code of Federal Regulations, Title 36, Part 800. Action: Acceptance of supplemental comments on proposed revision of current regulations. Summary: The Advisory Council on Historic Preservation, referred to as the Council, issued a notice of proposed rulemaking. This notice was published on October 3rd, 1994, in Volume 59 of the Federal Register, page 50396. The notice addressed changes to the Council's regulations on the protection of historic properties. A period of 60 days was provided for public comment in response to numerous requests for an extension of time to comment beyond the 2nd of December 1994 deadline. The Council extended the comment period for an additional 30 days. The current deadline of January 3rd, 1995 remains in effect and will not be extended further. However, in recognition of concerns expressed by some commenters for additional time to conduct detailed analyses, the Council will accept supplemental submissions from any commenters who wish to amplify or amend their initial comments. Accordingly, the Council will keep the public record open through February 2nd, 1995 for the purpose of receiving these supplemental submissions. Any materials received on or before that date will be fully considered as part of the public comment record as the Council proceeds with its consideration of regulatory revisions. Dates. The date on or before which comments must be received remains January 3rd, 1995. The Council will keep the record open through February 2nd, 1995, for consideration of materials supplementing comments received on or before January 3rd, 1995. Addresses. Comments should be addressed to the Executive Director Advisory Council on Historic Preservation, 1100 Pennsylvania Avenue, Northwest, Suite 809, Washington, D.C. 20004. Fax numbers 202 606 8647 or 202 606 8672. For further information, contact Stephanie Warnowich, Information Assistant Advisory Council on Historic Preservation, 11100 Pennsylvania Avenue, Northwest, Suite 809, Washington, D.C. 20004. Telephone 202 606 8503. Robert D. Bush, Executive Director. This document was filed December 30th, 1994 at 8:45 a.m. Billing code 4310-10-M. This concludes the current entry. There is nothing you need to remember. We will continue shortly. We will continue now with another entry from the Federal Register. You do not need to notice the change. You can simply remain at rest as the reading continues. Beginning the next entry, the Federal Register, Volume 60, Number 1, Tuesday, January 3rd, 1995. Rules and Regulations, pages 1 through 2, published by their Government Publishing Office. Document number 94-32287. Department of Agriculture, Agricultural Marketing Service. Title 7 of the Code of Federal Regulations. Part 929. File Designation FV 94-929-3 FR. Title: Cranberries grown in the states of Massachusetts, Rhode Island, Connecticut, New Jersey, Wisconsin, Michigan, Minnesota, Oregon, Washington, and Long Island. In the state of New York. Establishment of late payment charges, an increase in interest charges on delinquent assessments. Agency. Agricultural Marketing Service, United States Department of Agriculture. Action. Final Rule Summary. This final rule increases the interest charge from 1% to 1.5% per month. It also adds a late payment charge of 5% on delinquent assessments owed by handlers under Marketing Order Number 929. This marketing order covers cranberries grown in 10 states. This rule contributes to the efficient operation of the program by ensuring that adequate funds are available to cover budgeted expenses incurred under the marketing order. Effective date. This final rule becomes effective February 2nd, 1995. For further information, contact Mark Hessel or Patricia Petrella, Marketing Specialists, Marketing Order Administration Branch, Fruit and Vegetable Division, Agricultural Marketing Service, United States Department of Agriculture, Room 2522-S, Post Office Box 96456, Washington, D.C. 20090-6456. Telephone 202-720-5127. Supplementary information. This final rule is issued under Marketing Agreement and Order Number 929, Title 7, Code of Federal Regulations, Part 929. The order regulates the handling of cranberries grown in 10 states and is hereinafter referred to as the order. The order is effective under the Agricultural Marketing Agreement Act of 1937 as amended, Title 7, United States Code, Sections 601 through 674. This statute is hereinafter referred to as the Act. The Department of Agriculture is issuing this rule in conformance with Executive Order 12866. This final rule has been reviewed under Executive Order 12778, Civil Justice Reform. This rule is not intended to have retroactive effect. This final rule will not preempt any state or local laws, regulations, or policies unless they present an irreconcilable conflict with this rule. The Act provides that administrative proceedings must be exhausted before parties may file suit in court under Section 608C, subsection 15, paragraph A of the Act. Any handler subject to an order may file a petition with the Secretary. The petition may state that the order, any provision of the order, or any obligation imposed in connection with the order is not in accordance with law. The handler may request a modification of the order or to be exempted from it. A handler is afforded the opportunity for a hearing on the petition. After the hearing, the Secretary would rule on the petition. The Act further provides that a United States District Court in any district in which the handler resides or maintains a principal place of business has jurisdiction in equity to review the Secretary's ruling. A bill in equity must be filed not later than 20 days after the date of entry of the ruling. Pursuant to the Regulatory Flexibility Act, the administrator of the Agricultural Marketing Service has considered the economic impact of this action on small entities. The purpose of the Regulatory Flexibility Act is to fit regulatory actions to the scale of the businesses affected so that small businesses are not unduly or disproportionately burdened. Marketing orders issued under the Act are unique in that they are established through group action by essentially small entities acting on their own behalf. Approximately 30 handlers of cranberries are subject to regulation under the order. There are approximately 1,050 producers of cranberries in the regulated area. Most handlers and producers may be classified as small entities. The Cranberry Marketing Committee, the agency responsible for local administration of the order, met on August 23, 1994. The committee unanimously recommended modifying the administrative rules concerning delinquent handler assessments. The modification increases the interest charge from 1% to 1.5% per month and adds a late payment charge of 5%. Assessments are the primary source of funds used to pay committee expenses. Failure to pay assessments promptly results in added expense and operational difficulty for the committee. The authority to levy late payment and interest charges was added in 1973. A 1% interest charge was established by informal rulemaking in 1978. The current interest charge has been determined to be insufficient to ensure timely compliance. The increase in charges encourages handlers to pay assessments more promptly. A proposed rule was published November 10th, 1994. No comments were received. List of subjects in Title VII Code of Federal Regulations, Part 929. Cranberries. Marketing agreements, reporting, and record keeping requirements. For the reasons set forth in the preamble, Title VII Code of Federal Regulations, Part 929 is amended. Authority. United States Code, Title VII, Sections 601 through 674, Section 929.152, Delinquent Assessments. There shall be a late payment charge of 5% and an interest charge of 1.5% per month applied to any assessment not received before the end of the month in which the assessment was first invoiced, provided that if an assessment is first invoiced later than the 15th of the month, no late payment or interest charge shall be levied if payment is received by the end of the following month. Dated December 27th, 1994. Sharon Bomer Lauritsen, Deputy Director of Fruit and Vegetable Division. Filed December 30th, 1994 at 8:45 a.m. Billing Code 3410-02-P. This concludes the current entry. There is nothing you need to remember. We will continue shortly. This concludes tonight's reading from the Federal Register. Thank you for listening. If you are still awake, you may like this video or follow Sleep Galaxy Tales for more calm readings. Otherwise, you may continue resting. Good night.